Hey everybody, welcome back to the channel. I appreciate your time. Thank you for watching. It seems that my old friend, Dick Heller, yes, the Dick Heller of Heller versus DC, the landmark case in which the Supreme Court for the first time said, yes, the Second Amendment is an individual right. That Dick Heller, who you've seen on this channel, he has another lawsuit against Washington, DC, and the chief of the Metropolitan Police Department, and this is a good one. So if you weren't aware, Washington, D.C. actually limits the amount of ammunition that you can carry. No more than 20 rounds. Yeah. Well, this lawsuit, the way it's written, is fantastic. And I'm going to give you a couple quotes from the lawsuit. I'll have the lawsuit linked down below, and let's get right into it. So here's the first page of the lawsuit. Again, I'll have it linked down below for your reading pleasure. But we're going to jump down to paragraph 24. And it says, the plaintiffs, however, do challenge DCMR 24-2343.1 as originally adopted via a notice of emergency and proposed rulemaking, or an emergency notice, on October 31st, 2014. This regulation provided, a person issued a concealed carry license by the chief while carrying the pistol shall not carry more ammunition than is required to render the pistol fully loaded, and in no event shall that amount be greater than 10 rounds of ammunition. Now, only 10 rounds. So if you had a Glock 17, you'd have to download your magazine in order to be okay with the law. Now, one good thing, as I will say, is this lawsuit went into great detail to put forth actual factual events in which bad guys were shot numerous times, more than 10 rounds, and kept the fight coming. In fact, you see that more often than not, because putting little holes in people doesn't really affect them until the hydraulics leak out of the tank, if you will, unless you get a stopper in the triangle. So let's look at the next paragraph. It says, subsequently, on March 6th of 2015, the chief issued a notice of second emergency and proposed rulemaking, which, without comment or explanation, doubled the allowable ammunition a concealed pistol licensee could carry on his person. This regulation read, a person issued a concealed carry license by the chief while carrying the pistol shall not carry more ammunition than is required to fully load the pistol twice, and in no event shall that amount be greater than 20 rounds of ammunition. Now, those of us who are in tune with legal decisions, especially very recent legal decisions, New York State Rifle and Pistol Association versus Bruin, you know that there is no text, there is no history, and there is no tradition in the United States ever that said, whoa, whoa, settle down, buckaroo, you can't carry more than X amount of rounds because then you will be what we will see as John Wick. Doesn't exist, never existed. Let's go to the next paragraph. Bruin, Heller, and Wren require us to evaluate firearms regulations in light of the text, history, and tradition of the Second Amendment. There appears to be nothing in the text, history, or tradition of the Second Amendment that supports limiting the amount of ammunition that a person may carry for his or her self-defense. Now, George L. Lyon Jr. of Arsenal Attorneys is the lawyer who's representing Dick Heller and the Heller Foundation in this lawsuit, and he's also an attorney on another recently filed lawsuit against DC, in which law-abiding gun owners want to be able to carry their firearms on the DC Metro. And for those who've never visited DC, that's their transportation system, and it has an issue with crime. But they want that to be a sensitive place. Again, no text, history, and tradition of that ever happening. So this is the same Attorney Lyon on that case, if the name rings a bell. But this is what he said regarding this case. There is no historical analog for a limit on the amount of ammunition that you can carry for self-defense. Obviously unconstitutional. You should be able to carry the amount of ammunition that you believe you need in order to protect yourself, and that may vary. If I go to walk my dog at noon in my nice area, I'm probably good with my 5-shot revolver and 1 speed load, which is what is allowed to me if I'm carrying that gun in the District of Columbia. He went on to add that if he's walking the dog at 2 o'clock in the morning, that he is going to feel much more secure by carrying a bit more ammunition than that. There's a lot wrong with DC gun laws, and I think it's probably best to take them one at a time. That's why in the Metro Carry lawsuit, the only thing I'm attacking is the part that I think is the absolute weakest. One of the mistakes that has been made in some litigation is to try to do too much and end up not accomplishing much. It's easy to convince the judge that there's one thing that's wrong. It's a lot harder to convince the judge that there are 15 things wrong. My belief is the best way to eat an elephant is one bite at a time. So this is just one of the plethora, actually two, of the plethora of lawsuits that have been filed in the wake of the New York State Rifle and Pistol Association versus Bruin, using the standard that the Supreme Court said is the only one that exists, the text of the Second Amendment. And if it's not mentioned in there, then the government has to prove that it's in the history or the tradition of the United States. And one would agree, even people who watch my videos who are may not be pro-gun, one would have to believe that if you read all of the history books, none of this gun control ever existed until someone said, we need to disarm this populace, and there's a reason why. So take that for what you will. I'd love to hear your comments, no matter what side of this argument you're on. I'd love to hear your comments on this down below. To Dick Heller, thank you, my friend. I appreciate you. And as always, like I've told you many times, however I can help you, let me know. And please, if you want to stay in the know on this decision, on this court case, when the decision is rendered, and or any of the lawsuits that are currently being filed and are about to be filed, there's a lot, then subscribe to the channel down below. Hit the little button down below this video. Hit the thumbs up if you enjoyed the video or got something out of it, and share it, please, with like-minded folks or people who aren't like-minded, who need to wake up and see the truth, because that's the only way we abolish the YouTube anti-gun algorithm here. And until we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. That's what the Second Amendment is for. They didn't say how many pens you can carry to write a book, nor did they say how many rounds you can carry to keep yourself safe. I'll see you in the next one, y'all. Take care.